Hi, good afternoon. Welcome to RWC webinar, the community series. I'm Richard V from Richard V Chambers. We've had couple of, in fact, a lot of webinars over the last few months. One thing about the MCO and COVID-19, the behavioral patterns of lawyers have significantly changed from attending and conducting seminars and talks to conducting and holding and attending webinars. So RWC is pleased to continue our series of webinars. Today's webinar is about the COVID-19 parliamentary bill, which was, I think, presented sometime on August 12th for the first table on August 12th. And today we are quite fortunate to have, for now, two speakers. My friends, Kenny Lai from Perak Bar, member of the Perak Bar, fellow member of the Malaysian Bar, and Syahredzan Johan, who is a KL Bar member and also a member of the Malaysian Bar. Kenny Lai used to be the Perak Bar chairman, and he's the committee of the Perak Bar. And Shah served Bar Council as a committee member, as a council elected member, and in fact at one time was the chairman of the National Young Lawyers Committee. And on a more humorous note, Shah and I support the best football club in the world, Everton. So it's we are the only two Everton fans in the whole Malaysia, so you have a full quorum today of Everton fans. So without further ado, what I'd like to do is this. Today's webinar, we will first be discussing about the impact of the COVID-19 bill. The new bill that is coming up. We would like to discuss the legal implication of the COVID-19 bill. But before that, the way we're going to structure this webinar is that Shah will be speaking about the general observation of the webinar, and then Kenny and I will be discussing about the impacts of certain provisions. Shah will also be giving his view. Now, before we proceed, we'd like to apologize on behalf of our fourth speaker, Desmond Ho. He is actually traveling at the moment, and due to an unexpected traffic condition, he's been delayed reaching his destination. So we have advised him that to log in only when he has safely arrived at his destination, because he's traveling with his family. So for now, it'll just be the three of us, but Desmond will join in when he has safely reached where he's supposed to reach. Okay, without further ado, can I first ask each of you to introduce yourself for 1 minute, and then we will start the session. Kenny, all yours. Can you introduce yourself, Kenny?
I think I've been on this channel quite a number of times. I'm Kenny Lai. I'm from Perak Bar. For former chairman of Perak Bar and former council member, and of course football fan of a better club than Everton, which is Manchester United. Okay. Thanks.
You had to say that, terrible. You're terrible. Yeah.
I'm surrounded by all the Everton fans.
Yeah. Okay, give chance. All right, Shah, bro, all yours, bro. Shah.
Yeah. Hi everyone. My name is Syahredzan Johan. You can call me Shah. I'm a litigation lawyer. I've been in practice, I think, for 13 years already. KL Bar member, former member of the Bar Council. Served time with Richard and also Kenny in the Bar Council. Had the opportunity and the privilege of serving as Constitutional Law Committee Chair, Young Lawyers Chair, and I was also a member of the KL Bar Committee as well at one time. So that's me, and I'm really interested in to talk about this COVID bill because I think it's a bill that is needed, which I will talk more later. But unfortunately, there are some weaknesses to the bill.
Yep. Thanks, Shah. Nice to have you here. We've tried to get you here on a few times, webinar, but still,
ada jodoh orang kata.
I think from outside the group of council, many may not realize that Kenny, Desmond, Shah, and I, we have always been known as the four horsemen in council. Always together. Yeah. So don't know whether good or bad, but we're always together. Yeah. All right.
Gang pension.
Now we're known as gang pension because we retired from council. Yeah. Still serving but retired. Yeah. Okay. Now, for now, thanks for introducing yourself. Good to have the two of you back. Too bad we don't have Desmond here yet. I would like to encourage everybody here who's logged on, please share this video, hold a watching party. I'm going to do it soon on my private Facebook page. So, Shah,
Yes.
looking at the COVID-19 bill, maybe to set the tone of the discussion for this afternoon, which I believe will go on until about 5:15. We will be opening this session for Q&A later. What is your observation looking at the bill? Maybe you can also share your views about it, and maybe you can give us any guidance about other countries which may have a similar bill. All yours, Shah.
Okay, thank you, Richard. Okay, I think to start off, we must understand what this bill is about. And if we look at, of course, the title of the bill, it says the bill is entitled Temporary Measures for Reducing the Impact of Coronavirus Disease 2019, COVID-19 bill. So, and the whole idea, the whole aim of the bill is to basically mitigate, to reduce, and to provide relief and protection to people who have been impacted by this COVID-19 pandemic. Now, as we know, right now in 2020, we have seen how the COVID-19 pandemic is creating havoc and chaos and has forced us, not just in Malaysia, but all over the world. It has forced us to adopt a new way of doing things, this quote-unquote new normal. This phrase, for example, social distancing, and now they have changed it into physical distancing. Certain industries have not yet recovered from the impact of the coronavirus, especially, for example, the airlines and tourism. There's domestic tourism, it's slowly getting back on its feet, but overseas tourism, we're still impacted. The numbers that we're looking at, for example, unemployment, we had the worst in decades over the past, I think, 2 or 3 months. Only this for last month, it eased a bit. But still, it's a worrying number. And of course, recently we have seen the numbers for the GDP growth for the country, in which for the second quarter of 2020, we have actually experienced a what do you call that, a contraction instead of expansion. So all these things have certainly impacted the country, and most importantly, it has impacted the man on the street. It has impacted companies, it has impacted individuals, and so on and so forth. We can look at the numbers and so on and so forth, but what it actually means is that you and me and people who are out there, in a lot of ways, we are impacted by COVID-19. So a law that is that deals with the impact of COVID-19 is certainly needed. And I think there's no doubt about that. In fact, for Malaysia, a lot of people have been calling for this law to be implemented for a long time. I think way back in June and July, there were already articles and people saying that Malaysia should have a COVID-19 bill, because we are not unique in the world. Other countries have actually enacted similar bills to deal with the COVID-19 pandemic, the fallout of the COVID-19 pandemic in their respective jurisdictions. So we are actually quite late in tabling this bill. Now let me just touch a bit on what's going to happen. If, say, for example, right now, as Richard has said, it has been tabled, and it has not been debated yet. It's only been tabled in the Dewan Rakyat, and it will, I think, be debated sometime next week. And if the parliamentarians accept it and the Dewan Rakyat, passes it, then what will happen is that it will be sent to the Senate, the Dewan Negara. Remember, we have a bicameral parliament. So bills that are passed by the Dewan Rakyat must also go to the Dewan Negara. And the Dewan Negara will sit in September. And usually when bills are passed in the Dewan Rakyat, it will also be passed in the Dewan Negara, although that's not a guarantee. But most of the time that will happen. So even after it has passed the Dewan Negara, of course, after that there will be the royal assent and then a date of coming into force. And then only will the bill be enforceable. Now, we are looking at a time frame of the earliest that this bill is going to be enforceable is probably at the end of September, and more likely it will be the early parts of October. So we are talking about a time period of March where the MCO for Malaysia was first announced, 18th of March, if I'm not mistaken, and the COVID-19 bill being enforced at the end of September or early October. So that's about, I think, 6 months or so, where in between, a lot of things would have happened, a lot of contracts would have been terminated, a lot of people would have been impacted. Now, the bill itself, and I think I just want to touch a bit about the bill, the provision of the bill. The bill itself says that it is retrospective, so meaning it's supposed to start from the date of the MCO. However, there is a saving provision in which the bill says that if any action has been taken, whether by terminating a contract or taking action in court or any reliefs have been sought, prior to the coming into force of the bill, then that action is valid or it is legal, meaning the bill in that, or rather the law for those particular instances, it will not apply. So, for example, if say, for example, I'm renting a premise in a mall, for example, and I could not pay my rent, and then the mall basically issues me a notice, and I have to go out of the mall. If that happens within that time period, then I would have no recourse, essentially. So. And it actually makes sense why they wanted to do this, or why they would do this. If they don't have this, then I think it would create quite a messy situation where matters which are already in court, for example, and then people can just retrospectively rely on the bill. Or if, say, for example, someone has been evicted from the premise, if the bill comes into force, and he can rely on the bill, then he can come back and say that I should not have been evicted. And then what's going to happen? There's a new tenant. So all this chaos. So I would understand why they have these sort of saving provisions. But the problem is this: when you have a 6 months period in which you didn't, between the MCO, where the impact and so on and so forth, and the actual enforcement of the law, a lot of things would have happened. And the reality is, the bill, even if it becomes law, would not actually provide protection to the vast majority of people who would have already been impacted by this COVID-19 pandemic. Now, if we compare it with the Singapore Act, Singapore has a similar COVID-19 Act. And I think a lot of the provisions that we have inserted in our bill may have been at least inspired by the Singapore Act. Now, the Singapore Act was passed by their parliament in April, and their version of the MCO, I think it's called a circuit breaker, was also in April. So although the bill again was retrospective, it starts I think sometime in February, but because it came in tandem with the circuit breaker, their version of the MCO, therefore, even if there is a saving provision, it would not have the same sort of impact, or it would not impact as many people as our law, because of the fact that they made that decision to table the law early. Now we know in Singapore, they only have one chamber. Is unlike us. We're not bicameral, and they're not. But they are only have one parliament, and really they are what do you call that? They don't really have a strong opposition over there. So laws get passed easier there. But I would think that even if a similar law was tabled earlier in the year, I would not think that even the opposition MPs would be objecting against this sort of law. But the main problem is this, because the government took so long to have a full parliamentary session. They only decided to have a session in July. Whereas we had opportunities before this in May and perhaps even earlier to have a full parliamentary session. In fact, we could have a special session just to pass this bill, or maybe another COVID-19 related bill, just for that purpose, without any question time or anything like that. We could have done all that, but the opportunity was not taken, and now we are in a situation where we have a bill, a sorely needed bill, but unfortunately, it's a bit too late, and a lot of people would have already been impacted by this bill. But that's not to say that we should not have it at all. It should still be passed by Parliament, of course. Making amendments that needs to be made, and so on and so forth. Like I said, we need this bill, but it's too late. So I think that's it for now. Maybe we can discuss a bit further later about this.
Thanks, Shah. Very succinct and good general overview. In fact, I think with respect to whoever who sits in Parliament now, especially those who are sitting on the governmental block, I think everyone else in the country thinks similar to what you think, which is it's a bit too late. But I'm trying to be positive. Better late than never, I suppose. But I do agree with you, and I think Kenny also would have some observation on this. As fellow members of the bar, the three of us would have been exposed or seen some situations which our clients are going through. And I think most of our clients, especially those who are going through difficulties, would have preferred this bill to come out very much earlier. Then they would have been able to plan their economic situation better. But now, as it is, we have no choice but to live with what we had. And I'll say the elephant in the room, Shah, because you are now, I know you are a member of an opposition party, so you rather not say anything. I'll say that the only reason why we didn't hold the parliament earlier was the new government which took office in March this year. They were scared. They were scared to go to parliament because they were worried that they will lose a vote of no confidence. So the fear of their own power means they have now compromised the 20-30 million Malaysians' rights. I think it's unfortunate because many of us would have supported whoever the government was at the time because we needed to get this thing running. So I'll say it. So I'm very, very displeased with the what happened in March and April, where the government was more interested in themselves. With respect, it really looked like that. But they have come up with in my view, a fairly decent bill, covering quite a number of areas. So let's discuss it today. The legal implications as lawyers. We'll put aside politics. We'll put aside our political feelings. Let's see how we can assist our members and our clients today. Kenny, so thanks, Shah. I'll come back to you. Very good start, Shah. Fantastic. Kenny, you look at the bill, right? They have we have, I think there are about 12 areas that they have proposed amendments. And I know for a fact that you are a qualified mediator. And I noticed that in the bill, one of the areas that was proposed was the areas dealing with contractual disputes, and of which the bill proposed mediation. Do you have any comments about that proposed amendments, proposed provision, and the issue of the mediation? All yours, Kenny.
Right. If we were to look at the section, which is section 9, I think, it talks about mediation, and it says that any dispute in respect of any inability of any party or parties to perform any contractual obligation arising from any of the categories of contracts, yada yada, may be settled by way of mediation. So the key word here is actually may be settled. When you say may be settled by way of mediation, what is it that you're going to settle? Because I find this a bit strange. Okay, if you look at the act itself, it gives you a sort of a moratorium between 18th of March to the 31st of December 2020. In this period, you cannot sue or be sued, or if you have any disputes and everything, that there is nothing you can do within this period, right? Because I think that's what it's supposed to do. But then again, you put in a clause for mediation. So the question is this: if I cannot do anything within the period for any of my contractual issues that I have, then what are we mediating? You know, if we compare to the Singapore version of things, the Singapore has an assessor appointed. This assessor will then look at your case and then to say whether it is suitable to be brought to mediation, which is I believe theirs is quite also not mandatory, but highly recommended, I think. So if we are looking at mediation, then I think, look, it's a very good start. I mean, as a mediator, and I think I speak for most of my mediation friends, the Bar Council has about 600 people, 600 trained mediators already registered with the MMC. We are ever ready to assist this bill, and we should have it should have been, I mean, we should be taken into consideration instead of having the minister appoint. I mean, they can always say, look, with the Bar Council, or appoint a certified mediator or something like that. But it says here the minister may determine the mediation process. And MMC's mediation process is fixed. The way we do things, the way we are trained to do it, the role and how we conduct is all there. So I think they should actually engage the MMC to do so. That is my view of about mediation. I know it's good, but I think it needs to be shored up, because if you say you may be settled by way of mediation, there are concerns that it will lead to more litigation actually. Not everyone will be happy with the way things are, or some people may go into it just because they have to. But if they are, they really want to mediate, and they get a properly trained mediator, mediation should bear fruit. I would say that. So in this sense, I think I don't know how to put it, but mediation is good, but I think they need to sort of tweak it a little bit further to give it a clearer direction in terms of mediation.
I suppose maybe Shah can come in to comment after this, but I think they need to, the parliament may need to refine that phrase, because with respect, it looks neither here nor there. Because as a lawyer, again, we are talking today as a lawyer, not as a rakyat only, but as a member of the bar, how do we advise our clients? So, like Shah already mentioned earlier, that the act is retrospective. So we have a breach of contract which happened maybe about 4 months ago, and parties are still now negotiating what to do. Are we going to quickly advise our client to file a suit now? Because it looks like if you file a suit now before the bill pass, okay, right? Can it, Shah, right? It looks like that, right?
Yeah.
If you are acting for the person aggrieved, you will tell your client, look, now you have the next 1 or 2 months before it's passed to go. And if you have who has done something wrong, you tell him, look, drag it as long as you can, you know.
It looks like Parliament impliedly has encouraged litigation. It's impliedly, you know, impliedly. I know it's not done on purpose, but unfortunately, the consequence of that provision it may mean more lawyers would advise the client to file a suit first, and can't blame the client and the lawyer. If the lawyer, the funny thing is, if the lawyer don't advise the client that, the lawyer may be negligent, for not advising the client that.
No,
So-
and Richard, I think it's not just filing suits. I think it goes beyond that. It says like for example, Section 10, it says any contract terminated. So you don't have to wait for lawyers to advise you. Anyone who reads this can know that, okay, I better terminate the contract now, and it would be a valid termination. So I think that's the issue with the saving provision.
I agree. And just Kenny have brilliantly pointed out, even when I was reading it the other day with my team, my law firm team, the word may refer to, I'm not sure how does that work actually, right, Kenny?
Yeah, it's quite unclear. It was seen to suggest that, look, you should go for mediation, but you don't have to. So if you don't make it compulsory for people to mediate, then why did you put a clause there for mediation? If you make it compulsory, then everyone has to go for mediation. Of course, you have to understand that mediation does not guarantee a successful outcome. But if a properly done mediation with proper mediators, trained mediators, there is a high success rate, of course. And if you come to an agreement, which we usually put it as it's a win-win situation for both parties, then that particular settlement can be recorded and can be enforced after that. So the mediation part is very good. Because we want everyone to be happy, because this is something that's none of us actually foresaw. The way that the world is now, and look, everyone's affected. It's not only the aggrieved party or the party being breaching the contract. There could be a reason why they are breaching the contract as well, isn't it? They can't afford it or whatever it is. Business has been
so I suppose so I suppose for yes, Shah.
No, I just wanted to ask Kenny. Do you think, because you mentioned the Singapore Act, which I think talks about appointing assessors and all that, right? Do you think that for our bill, it would be better if we make it like mandatory or something compulsory for any party who wants to take any legal action to first explore mediation?
I believe that would be good. Yes, I would believe that would be good. Actually, you make it compulsory for them to go through mediation. Of course, there are people who will say, look, they may use mediation as a fishing technique, to get to know what other side's powers is and all these things, what they have in their hand. But like I said, a properly done mediation would actually really help the parties come to a proper solution between the parties.
And should they actually say that mediation by a mediator from the Malaysian Mediation Center and all that, just to make it?
Why not? Because they do know that the MMC, which is the Malaysian Mediation Center set up by Bar Council, has been in existence for a long time. Four members, all throughout the state and everything, and we've been doing mediation for a long time, right? So accredited, all properly trained. Why not? Why not put it? Unless of course the government is trying to do their own mediation, and then again, are they properly trained as mediators as well? So I don't really know what they want to do, but like I said, the Bar Council's MMC is ready and ever willing to assist. And, we would be in a prime position to help solve this problem, actually.
Well, I suppose for now, our mini conclusion for now is that for purposes of the contract, if you have any ongoing disputes, I think let's quickly sort it out, and if you have to file a suit now, and terminate now, which is unfortunate because by right, as three of us, we do litigation. The irony of litigation is to try and avoid litigation. But anyway, that's one area. And secondly, it looks at the mediation one, subject to the final, let's say, what is the final version of the bill, which comes up as an Act of Parliament. If it stands as it is now, there is a possibility that we may just ignore it, because they just say may go mediation. Just ignore it, So for now, but I would recommend my clients to go for mediation. I would try to spirit of the bill and say, look, let's go for mediation. Avoid the court. You spend more legal fees. Why not? Why do you want to spend legal fees? Go for mediation, cheaper for you. Blah blah blah. I think as a lawyer, we should try to guide our client that way. Yeah.
Correct.
So now moving on, we've got a lot of other topics to discuss. Let's quickly say this. I think we all now notice that for the limitation period, it looks like for the Sabah Limitation Ordinance and the Sarawak Limitation Ordinance and the Limitation Act 1953, it seems that any matters where the limitation period fell within this MCO period, it shall be now extended to 31st December 2020. So that in a way helped litigate, because they were denied the opportunity to file a case in court during the MCO. So it looks like now the party may revive mati hidup semula revive and quickly go and file, isn't it, Kenny?
Yeah, okay. That is the thing. I was looking at it and I found it a bit strange. Okay, if my limitation period for filing, let's say, ends, for example, say in May. Okay, so May the 2nd it ends.
Yeah.
So now with this new COVID temporary measures COVID Act, it gets extended to 31st of December. Right? So do I get an extension up to 31st December? Because up to 31st December, I can't do anything as well. According to the Act, I cannot file anything.
Yeah.
Yeah.
Because of the breach,
yeah. So the breach is within that period. So we are talking about the 1st of January onwards, I can file. So does my limitation run for, let's say, 18th of March to 2nd of May, the extra 2 months? 2 months after the 1st of January, or does it end on the 31st of December? I've been trying to read it. I may have missed
good
it.
Point. Very good point.
Yeah.
Sure.
So do I get another 2 months, or do I just have up to 31st? I don't know. I really find
before I invite Shah, so we have it's like we got this guy excited. We tell the client, "Ayo, client, sorry lah, your limitation period is mati, but hey, you can sue again until 31st December, but cannot lah."
You can sue until December, but you cannot file. File then, okay. So 1st of January now I can file, but is it the end of my limitation period?
Yeah.
Or do I get an extension of 2 months after?
Correct. And that person cannot file now because this bill is not in effect yet, and therefore the limitation period has taken effect, and that limitation period has already blocked his or her right to sue.
So maybe I didn't read the Act properly, or I couldn't see it lah. I would hope someone else who had read it could tell me, but I don't see it. I'm not sure.
Maybe this is a situation where they're talking about contracts which have occurred prior to the MCO, perhaps, where you want to file maybe like nearly 6 years ago, then you want to file, and then suddenly the limitation period is within the MCO, and you can't get a lawyer to go and file or something like that. So now it's extended. Maybe that sort of situation. I'm not sure, but Kenny brings up a good point. Yeah,
you're right. You see, you get an extension to file. Because you extension of limitation.
Yeah.
But the end of the extension of limitation is up to 31st of December. This extension period, you can't really file anything as well.
Yeah.
So you seem to be caught in a quandary here.
Unless Kenny, you see the provision pertaining to the contract part, where it limits, or should I say it injuncts people for contract, it seems to suggest that the breach of contract occurred during the MCO period and you couldn't file, and now we want you to do mediation, etc.
Yes, okay, fine.
But this limitation period issue, contohnya the breach of contract took place obviously long ago, and therefore it should not injunct you from filing lah. if you interpret it that way,
Because if you say that it's only because of the COVID-19 that you are in breach of whatever contract, then it's only for those cases lah.
yeah, it
Yeah,
looks
yeah,
like that.
maybe lah, maybe.
Maybe.
The law could be drafted better, definitely.
Yeah.
I believe the Singapore one is quite specific that only things that happen because or due to the COVID-19. You know, so this one is a bit more general in that sense. So you say only because of it, then yes, then you have a better drafted thing. But then again, I believe Lishi talked about this as well in his article.
Yes,
said,
he wrote a good article. Yeah,
caused by COVID-19. That
yes,
is the thing that they have to define as well. It must be defined out as well. How and what do you mean by something that happened or your breach is caused by the COVID-19 or the pandemic? You know, how do you define it? I mean, okay, look, directly impacted. Let's say you cannot open business, and yeah, you are directly impacted, but there are subsequent run-ons from that. You know, I mean, you're not directly, but somehow as a cause of it, it happens as well. So I think it's a bit more. You need to be a bit more specific, or it needs to be refined further and give it a bit more thought before you can really picture it.
Yeah. So, but I suppose for the purposes of limitation, while I totally subscribe to your view, Kenny, but maybe the way forward is the detailed reading of the words. Just like what Lee Shi's article wrote, but I think his one was on a slightly different area. But the emphasize on that. And for those who don't know, Lee Shi is a fellow member of the bar. He's a partner of Mercer's Lim Chiwi Partnership, and he is a prolific writer. You all should go visit his website at malaysianlawyer.com to see his article. But moving forward, gentlemen, unfortunately, I think Desmond is still driving. Poor Desmond. So moving forward, gentlemen, you look at the other parts of the bill. It deals with, for example, the issue of bankruptcy. Is now, I think the amount has gone up, right, Shah? It's raised from 50,000 to 100,000. So you cannot initiate a bankruptcy action unless you have a judgment of 100,000 ringgit and above, right?
Yep.
It looks like that. Yep.
It looks like that.
But this is only for the this period as well, isn't it?
It looks like that, yes.
Yeah.
Because the active period is based on, as you know, the act of part. The bill talks about one general active period. The general active period is between COVID.
March to 31st December 2020.
Yeah, and in fact, not just that, Kenny, it says it's operational for 2 years. The bill is supposed to operate for 2 years, but for certain provisions, contohnya for the contract issue, it will be active period is 18 March to 31st December. But general law is that this bill can cover until 2 years.
They can extend it.
They can extend it for the next 2 years. But the active period is that period, as you said, Kenny. So the active period, from what we can read in the bill, it says that it comes into operation on the date of the publication of the act, and it goes on until 31st December. Or for 2 years, it can go on 2 years.
Yeah.
So that is still for yet to see lah. Let Parliament amend the law, if any. Then when we see the act, then we probably have a second webinar on this.
Just talking about the the Insolvency Act. I keep referring to it as the Bankruptcy Act, but it's now the Insolvency Act.
The Insolvency Act. Sorry.
Yeah. No, I mean, I make the same mistake because we have for the longest time known it as but just touching on that, right? You are absolutely right, Richard, that they have increased the debt, what do you call that, the amount of indebtedness that you can actually take action and so on, which is good. I think we have no issue with that. We don't want we know that there are a lot of people who are impacted by COVID-19. You don't want a lot of people to suddenly become bankrupt and all that. But again, the problem is there are the saving provision which says that any proceedings or actions which you have taken prior to the date of publication of the act is taken as if the Insolvency Act has not been modified, meaning it's valid. So if you have taken action now before the act comes into force, then and you have taken action on the basis of
the basis of,
the lower indebtedness,
2,000.
then it's completely
okay.
valid.
Okay.
Yeah.
Apparently it's okay.
So this is again goes back to the whole issue of being too late. And again, I think we know why the saving provision is there, and I think we all can agree on an objective sort of view that you would need some sort of saving provision, or else it'll just be chaos. Because you things which are already in court, suddenly you want to delay things so that you don't want it to go on, and if there are matters which have been terminated, suddenly they can come back and say that it's not terminated. So there'll be a lot of problems. So we understand why there are these saving provisions, which is littered throughout the Act. But again, the problem is because the law is tabled so late, and that's why the saving provisions have a bigger impact than it would be as compared to perhaps in Singapore.
Agreed.
This is one example of it. A person who has already been made a bankrupt now, or in the process of being made a bankrupt, then they have little recourse.
Yeah. Well, we'll see when the act comes up. It will come up, but for now, it is the bankruptcy part is not too bad. There is some clarity that even in this current form and format, but maybe if they can refine on how the quantum came about, etc., then we'll see. And furthermore, I think the Hansard is very important. I really hope there will be a proper debate instead of some shouting in Parliament, so that when we go through in the Hansard, people, the member of Parliament, sometimes they underestimate the importance of the Hansard.
Yeah, that's
we
true.
lawyers, we refer to the Hansard and use it to interpret the act in courts. But it's very embarrassing when we see the Hansard about gado, then it doesn't help the interpretation. Anyway, so we hope that there will be a proper debate. Now, flowing from there, the next one, I would like to invite maybe Kenny to have a comment. Apparently, Kenny, there's issue pertaining to the Consumer Protection Act Credit Sales Agreement. The modification of Section 24 sub 5 of the Consumer Protection Act. It deals with the credit facility provider. I think it's pertaining to loans and whatever. You have any comment about this?
Actually, Desmond's supposed to comment already, but this one they talk about modification of the particular act, isn't it? Before
correct.
But then again, if you are, isn't there a moratorium that there is no? Technically, you're not supposed to pay anything now. I mean, I don't know.
Yeah. I must confess, I'm not familiar with this amendment. And then, even though my firm wrote an article about this, it was written by my colleagues, and they gave a comment on that. Bravo to them. But I understand it's pertaining to a Consumer Protection Act, and you're right.
But I think this one is a very, very specific period, because if you look at 24V2, I think, this section 24 modified section 1 shall only apply if the credit sale agreement was entered before 18 March and if the purchaser has no overdue installments before the 18th of March. So you get protection during this period, but if you happen to sort of not pay or do anything before that, I believe then they can proceed. But
should be okay. But we'll see. Unfortunately, you're right, Kenny. Desmond was supposed to cover. I forgot. It's not you and me.
But then again, if you look at it, why do you need to say that in the first place? If it's before the 18th of March, the normal law applies, but isn't it?
Interesting. We'll see that. Good point. So moving forward, maybe Desmond can pop in shortly. On the next issue, we also see maybe Shah here. Shah, are you familiar with this one? The issue of a warrant of distress. Apparently, it says that the Distress Act 1951, the active period is again 18 March to 31st December, and it says for the time period from that 18 March to 31st August, no warrant of distress issued under Section 5(1) of the Distress Act shall include the distraint for the areas of rent for purposes of recovering rent. Is this what you were mentioning earlier about the rental of the shopping mall?
This is under the Distress Act. It's where it gives the landlord the right to actually issue a warrant of distress. If say for example the tenant has not been paying rent, so you can issue out this what do you call that? This warrant of distress, and then what you can do is you can actually sell off the movable property of the tenant in that particular premise. So basically what it says here is that if say for example that arrears of rent is within that period of 18 March to 31st of August, then you cannot take distress action. Essentially, that's what it's trying to say. Which is again, it's a good thing, but there is of course a saving provision, which says that if you have taken action already, before the publication of the act, then whatever you have done is legal. So, if anyone who has taken distress action against their tenant for non-payment of rent within the period of the MCO until whenever this comes into force, then they would not. That action would be legal. And just to also touch on this issue of rent. Under Section 7, about the contractual obligations and so on and so forth, inability to perform contractual obligations. In that part 2, there is a schedule where it actually lists down the categories of contract in which if there is an inability to perform the contractual obligations for these particular types of contract as a result of COVID-19, then Section 7 would kick in. And one of the categories is lease or tenancy of a non-residential immovable property. Meaning, the example that I gave of a tenant in a mall, for example, that would fall under lease or tenancy of a non-residential. Or maybe you give another example, just renting a shop lot or whatever. That would be a non-residential immovable property. But it doesn't cover lease or tenancy of a residential property. So and I personally also have had a lot of people come to me and tell me that they have had to leave their rented houses and so on and so forth because of their inability to pay COVID-19, and their landlord has asked them to move out and all that. And it would appear that apart from the distress protection, which I've touched about before this, there doesn't seem to be a protection per se against eviction of of residential leases and tenancies. And I think this is something which the government should look at, because apart from the commercial or the non-residential immovable property, I think a lot of people has also been impacted by the COVID-19 because of landlords. So perhaps not to say that landlords cannot evict their tenants and so on and so forth. I think that may be a bit too one-sided, perhaps for the tenants, but perhaps we can have a framework in which you need to go through a mediator before you can take action.
Mediator.
In Singapore, I think what you need to do is issue out a notice of relief or something like that. So something similar to that effect, where you must have some extra action before you can actually enforce your particular rights under the act. So something in the middle where you want to make sure that both parties are protected, and we can actually try and solve the issue amicably. But it doesn't seem to cover this sort of contractual relationship. So I think this is something which the government should look at and find a way to deal with this particular aspect of contractual relationship.
Yeah, good point. I think you really covered the whole thing there. But let's see how the final bill comes up. I think that will be the theme of our statement today. While we are discussing, we are not going to make any conclusion. I don't think we are in any position to advise anybody yet. But as members of the bar, we looking at the bill, we can make comments. Hopefully, some of our comments will reach the member of parliament. Now, moving to the next issue, I know Kenny's partner is a conveyancing lawyer. I may even give some comments. Apparently, for they've modified the Housing Development Control and Licensing Act, particularly for late payment charges, delivery of vacant possession, liquidated damages, and DLP, the defective liability period. So it looks like now, for purposes of, for example, delivery of vacant possession, I think we normally call it delivery of VP. So the VP is now, if you're supposed to deliver anytime between 18 March to 31st August this year, that time period will be excluded. And the developer may apply to the minister for an extension for the period up to 31st December, apparently. And this is, I think, with regards to the liquidated damages. So there is some leeway given to a developer because...
So I mean, this one would mean that, let's say, I'm supposed to deliver, let's say, again, like in May or something like that.
May, our favorite month.
So now if we apply that, the developer applies to the government and gets the extension, would that mean that they would have extra 2 months in January and February because this whole period has been taken out of the calendar?
It seems so, Kenny. But at the end of the day, I must comment. While I'm not here to defend the developer, all of us are house buyers here. But with the latest federal court decision, where now vacant possession, the timeline to calculate delivery of vacant possession is from the day, not the SNP. I understand there's a federal court decision which say that the day starts from the day you sign the OTP, the option to purchase, or the offer letter. So actually, there's a
recent development, isn't it?
Correct, it's a recent development. It happened earlier this year. Unfortunately, I've not had the liberty to read the decision yet, but I've read articles about it. And actually, for the developer, it's more like I get discount for these few months because they are already going to kena the LAD for late delivery, so they will be delayed. But I probably will invite a few conveyancing lawyers in the next webinar to discuss this. There are some issues on conveyancing here. Unfortunately, I think all three of us I'm hardly do conveyancing nowadays, even though I am experienced in conveyancing. But better to get experts to comment about this.
But then there's this one thing where I think I was reading about it. Where you are unable to enter into possession of occupation of the housing accommodation. So I think I'm specifically talking about 35(4).
Yeah, correct.
Okay. Unable to enter into possession of occupation of a housing accommodation. That means the purchaser cannot.
They can't go in. They can't get in.
So, what do you mean by can't go in? And how do you define can't go in?
I suspect, Kenny, this is my interpretation when I saw that. I think it is actually governing the situation during the MCO because people couldn't move.
Yeah, so you cannot take physical possession, basically, right?
Yeah, physical possession, they can't take it, They cannot even go to the developer's office to take the key, for example. So maybe, I think they're dealing with that.
So that's why the question is, how do you show the inability to take vacant possession? What do you mean by inability?
By that,
So if I'm in, let's say I'm in Ipoh, and I bought a place in Kuala Lumpur. During the MCO, I can't travel. MCO, I would be able to travel. So, what if I say that it's not safe to go to KL, let's say, because I feel that there's a cluster there. So is that inability on my part, or I think it's be a bit
inability,
or to define what do you mean by inability?
Good point, Kenny, as usual. I think you saw that.
Maybe
may invite, subject to time, may invite some conveyancing lawyers to come and give comment on that. I think we should be a bit careful with what we say, because we get something accurate.
But I think our viewers will have to understand. We are also like you know, we are commenting on what we see and what we read.
Yeah.
We're not making the law. You know, we don't really, but we see that certain problems do arise, which may have been answered somewhere along the line, which maybe I didn't read about it.
We're not aware, Well, we'll see. That's what the webinar is here for. At the end of the day, my hope of holding all these webinars is to provoke thinking, to encourage a discussion, you know, and don't just jump to conclusion. And I think all of us during this COVID-19, as I said earlier in our webinar, our behavioral pattern have changed. This webinar is for that, for us to sit down and listen to all these kind of views. Okay, good point, Kenny. That point, honestly, I didn't see that point. The definition of that one. Good. Next one, maybe Shah may want to comment this. Employment matters. We're coming to the end already. Apparently, Shah, for the employment matters, there's a modification to the Industrial Relation Act. It says that I think this is for those the calculation period. The trade union. So I think this is good.
Yeah, this is good for you to basically, you know, if you want to make what do you call that, a complaint or to file a lodge a complaint with the industrial relations. Basically the what do you call it, for industrial relations matter lah. So it basically allows a longer time period.
So contohnya, if you were supposed to file your industrial relation complaint in April or May, based on a 60-day period, so it now looks like you are allowed to file even now. Even now you're allowed. Because I think this is in a way deals with limitation period, but the limitation period which is specifically for IR matters. So I think this is good.
I think there was also a case of you know, a limitation period, or rather the time frame in which, because of the MCO, it cannot be filed because the industrial relation, the office is not open during the MCO. I think there was a case that was reported earlier this year of the situation. So this amendment or this clause would actually deal with those sort of situations. And I think, of course, it's a sorely needed again provision.
Shah, the case that you talk about, what happened? Did they manage to file?
I think they did subsequently file, but I think there was an action also filed in court to try and extend it. I'm not sure what was the conclusion of that case. It's just that it was reported that they could not file it within the time period, and I think there was criticism with that because of the fact that, you know, you have to actually impose it statutorily. So the minister cannot simply extend the period based on his discretion or whatever. So that's why this is needed. So you need to have an amendment to the statute.
Agreed. In fact, during the MCO, personally, I was approached by a client who wanted to lodge a complaint, but unfortunately, the timeline is during the MCO, and I think that client is now quite happy to see this. And when the bill is passed, I think that client will eventually file a complaint, lodge a complaint. Okay. Moving on. Second last area. This is, I think, out of our comfort zone because none of us do areas related to public transport. But there is an amendment for the license application to renew the license for the buses and public transport. That any license which expired during the MCO, you can now file later. You can renew later. So I assume this will help all the bus companies, the public transport companies.
I'm not familiar also.
Like I said, maybe it's because the bill is so late in the day. All this seems to, I mean, you would have already renewed it by now, isn't it? You could have renewed it by now already, right?
But I think they're dealing with
still when you cannot do anything. So if you cannot renew, technically you couldn't even drive the vehicle around.
The bus, yeah.
It's the same thing for our licenses and our passports and whatever it is. If it runs out, our licenses especially.
But Kenny, what is
Go-
interesting is for these areas of proposed amendments pertaining to the Land Public Transport Act, the Commercial Vehicle Licensing Board Act, which deals with all this public transportation, the active period is 1st of August 2020 to 31st December next year. This is the active period. Yeah. So, but I said, because I'm not personally not familiar with the Land Public Transport Act and how the thing works.
How those things work. Sure.
Yeah. So it's something to do with the licensing, which happened around this time. So, again, we may need to get somebody who is very well versed with this area to comment. But for now, looking at it, I don't think we are in a position to give a in-depth comment unless Desmond was supposed to comment. Maybe Desmond knows something. Yeah. Okay. Yeah, we just blame Desmond lah. Everything we just say Desmond lah. Okay, last area.
Desmond says he's arrived.
Yeah.
Oh, okay, yeah. Don't know whether he can still come in.
Ask him to come in.
Just ask him to come in lah. Just ask him to come in lah. Okay. Now, last area before we got a question from Sukhdev Sran. Last area is about our Chief Justice's power. According to the modification proposed, the bill will propose to modify the Court of Judicature Act, the Subordinate Court Act, and the Subordinate Court Rules Act, which effectively inserts a power that the CJ is able to modify any provision in the rules of court to suspend the application in the dispensing justice, etc. Even for the Subordinate Court Act, it says that the CJ has the general power, same thing, to see fit to do what is to dispense justice. And for the Courts of Judicature Act, it proposed to amend Section 17 of the current Act and add in a new provision to 16A. And the 16A part to amend is to allow CJ the power to, again, do what is necessary to dispense justice, and to amend Section 17 to, they want to renumber and to give the power to the CJ to adjourn any meeting, etc. So basically, it is allowing these powers of the CJ to make any amendments, any rules which will then allow our the court to move on, right? Shah, Kenny, before we bring in Desmond.
No, he's already in. I can see him.
I know. I added him already. So before we let him talk first, Kenny, Shah, anything you want to comment about that power?
No.
I think it's a sort of a power to allow the CJ to do anything that needs to be done, which just I think it should be there.
Yeah.
Every time it'll be very difficult for them to actually do anything.
Correct. So Desmond, how are you? Have you safely arrived wherever you're supposed to arrive?
Yes, goodness.
It's a long drive.
Yeah, long drive, isn't it? You shouldn't travel on a holiday.
Yeah.
Okay.
4 hours.
Desmond, we were wondering, welcome aboard. For those who don't know, Desmond is a member of the Malacca Bar and Selangor Bar, former chairman of the Malacca Bar Committee, and he is, as you can see, is a fan of Arsenal Football Club. So this webinar have the membership of 3 very important members of the 3 early original members of the league clubs which came later. They moved into other people's stadium, took over other people's stadium. They are later club. So the 3 of us are among the original membership of the Premier League or the English League. Yeah. So Desmond, you have any comment pertaining to the Consumer Protection Act? I think you were supposed to comment that actually. Are you familiar with that?
Do you have the act? Sorry, because I just got in only.
Yeah, I can see you're tired. You see, apparently it says here under the new.
My apologies because I'm not on my laptop.
No worries, no worries. So the Consumer Protection Act is going to be amended by the COVID-19 bill, and it seems to suggest that it's going to amend Section 24V of the Consumer Protection Act, where the credit sales agreement entered before 18 March, and if the purchaser has no overdue installment before 18 March. Hello? So basically, Desmond, it deals about credit sales agreement, and neither Kenny or Shah or I are familiar with this area. Do you have any comments on this area? Before 18 March, and if the purchaser has no overdue installment before 18 March.
So I'm not getting the audio.
Hello? Oh, you're not getting the audio, is it? So basically, Desmond, it deals about credit sales agreement, and neither Kenny or Shah or I are familiar with this area.
Guys, sorry, I'm not getting the audio at all. I can't hear. Anyway, can you just continue first then?
Okay. I tell you what, Desmond, can I remove you first from the group? I remove you first, huh?
He can't hear.
Yeah, I think he can't hear. There's a problem. There's a lagging. Okay, never mind. We'll move on first.
So there was sorry?
Yes, we have a question from the floor. From Sukhdev. Sure, very good question. Rentals not paid since a year ago till to date or not qualify as the inability to perform, that's the word, due to COVID-19. Reading clause 7 and 9 of the bill, court action could be filed even if the COVID-19 bill is passed. Am I right? Yeah. Any comments?
Yeah.
I think it's right because the cause of action occurred before the 18th of March.
Yeah.
So it's a year ago already. So I think I don't think it's caught by the Act, or he'll be unable to do it from the Act. Should be able to file. Shouldn't be a problem.
Yeah.
If you're acting for the poor fellow who didn't pay, you will try your luck.
Yeah, I think it's correct. Unless, but of course, it says to date. So I think
Still continuing.
what we'd have to look at is, I think, because the bill is only between 18 March onwards. So if any change or any impact or effect of the Act would be for bills or for rentals which are not paid from 18 March onwards. Prior to that, I think there's no issue or there's no change. So you can still take action against
So maybe the calculation will be up to the 18th of March. So March, you will fall under the Act and you cannot chase for that amount.
Yes. Unless you do it now. Unless you do it now before the Act comes into force.
Before the Act.
Yeah.
So Sukhdev, do it now. Within the next month or so.
But thanks for thank you for the question, Sukhdev. Have a good day to you. Yep. And then from Dato Shamshuria, she said she missed Desmond. We miss Desmond too. Yeah. Hi Dato, how are you? Yeah. Now, so to summarize the discussion, gentlemen, it's only 5:15 as we targeted. Memang now it's 5:09. We got 6 more minutes. Maybe unless there's questions coming in, maybe Kenny, would you like to maybe give your summary of what you think about the bill, and then I will invite Shah to wrap it up before we close it for the day. Unless there's a question coming in, Kenny.
All right. I think we definitely need this bill. Unfortunately, I think it's a bit late in the day. So a lot of things that they tried to sort out has, in a way, been sorted out already, in a sense, because it has already been about 5 months or so since the MCO, and the lifting of the MCO was about 2-3 months already. Lifting of the MCO, but not the RMCO. But I think we need it because there are quite a number of people who are still caught in between. So it's good that we have this. It needs to be refined slightly further. Maybe a discussion with, again, with Bar Council or people involved in whatever doing. We give them a better idea how to refine it.
Mm.
Then yeah, it should. Well, I hope it comes through and passes soon. If not, it would be a waste of time, isn't it?
Agreed. Yeah. But suppose, like I said, I'm trying to be positive, better late than never. And as I mentioned earlier on in the show, I think the elephant in the room was that we didn't hold parliament because of the change of government in March, in end of February, March. And that government, I think the current government was, in a nicer word, the nicest I can say, they were afraid of Tun Mahathir's proposal for the vote of no confidence. And I think we respect the effect that it made people like me felt like they were afraid of their own position as compared to concern for our position as rakyat. But it's done. What to do is done. We will support this bill wherever we can to help the people. But Shah, you have any comment? Maybe you want to give your summary about this?
I agree with Kenny lah. I mean, I think it is needed, and which I've said earlier, and a lot of the provisions are good and timely, or well, not timely, but it must be done actually. So it's sorely needed. But I also am quite curious also as to what the Bar Council thinks about this COVID-19 bill, because as far as I know, I think they haven't come up with a statement or memorandum or anything like that to talk about the bill. So I'd like to know. I mean, it would be good to get the perspective from the Bar Council. You would think that they are the go-to guys when it comes to legislative bills and all that. So I think it would be good if they can come up with their views on the bill as well.
Yeah,
that's it for me.
Yeah, thank you, Shah. I agree with you on the part about council. I think all three of us and Desmond, who by the way is now recorded his apology here. I think being former council members, we know that as council should and ought to issue a statement out. But we also know, to be fair to council, there's a lot of work when you are in council, especially as office bearers. So I think Salim and gang will have their work cut out, and I would not be surprised while we're talking. Actually, the four of them are already drafting something out. So we'll wait and see. But it will be good. But I would, if they are not, then I encourage them and implore them to please come up with something so that it will be a good guidance for us rakyat, and to come up soon and quick, maybe by next week. It will be good. I too would like to be guided by my council. But so, ladies and gentlemen, thank you so much for logging in, and speakers. Once again, except poor Desmond, who unfortunately was caught in an unexpected traffic jam. Kenny, my brother up north, you are the king of the north. Thank you once again. Yeah. Kenny, nowadays people know that whenever there's a webinar, it's always Richard, Desmond, and Kenny. And then, like Shah reminded me yesterday, that he was part of our CPD Express last year when we did it. But we missed Shah. We always wanted Shah to join us.
Busy man.
Because Shah will be our future member of Parliament one day, and so we are looking forward to Shah to take over Parliament one day and go and do something, but no vaping in Parliament, Shah, remember that. So, and thank you very much, Shah, brother.
Shah, salam mal Hishra.
Salam alaikum, Shah.
Yeah,
salam.
Yeah, happy New Year.
Happy New Year.
Yeah.
So, to everybody here, can I invite all of you to give a cyber round of applause to Kenny and Shah? They prepared. Also to Desmond. For the record, Desmond really prepared for this talk, but he thought he would arrive his destination at 2:30 to 3 o'clock, but at 4 o'clock he was still driving. So thank you, Desmond, for preparing. And to all the listeners, you could be anywhere today, now especially with the MCO being more liberal, you can travel around, but you choose to log in and listen. Thank you very much. Those who missed this can still watch this because it can be replayed on Facebook. But within the next 48 hours, it'll be uploaded on the RWC YouTube channel. You can watch it on YouTube anytime. So thank you very much. Adios, amigos. Speakers, hold on. I'm going to end the live broadcast.
Stay safe, everybody.
Take care. Stay safe, everybody. Adios.
Thank you.
Bye-bye.